Hello everyone, this is Undiga Emuekpere, the Niger fertility lawyer. And today I'd like to share some thoughts about the effect of the lack of surrogacy laws in Nigeria on the fertility treatment plans of intending parents who come to Nigeria for either surrogacy, IVF, or gamete donation, or the use of other assisted means to have children. Very often, intending parents ask me, "Oh, I heard that we don't have laws on surrogacy in Nigeria. So, does that mean that we can do anything that we like?" Actually, the truth of the matter is that although we do not have laws that are specifically for assisted reproduction or which are applicable to surrogacy, we do have existing laws in Nigeria that affect many aspects of assisted reproductive technologies in different ways that people do not really anticipate. So let me start with explaining how the fact that we don't have laws in Nigeria affects surrogacy. Now, in a surrogacy, a woman, known as a surrogate, assigns an agreement and agrees to carry a pregnancy on behalf of someone or some other people, to the extent that after the child is born, the child will be handed over to those people and all the necessary documentation and processes effected to make sure that there is a transfer of parental rights from the surrogate to the intending parent or the intending parents. That is ideally what should happen in a surrogacy. Now, in Nigeria, because we do not have surrogacy laws, we already have laws on our books which apply and which define who a mother is and who a father is. And those rules are what we call default parenthood rules. Under the default parenthood rules, a woman who carries a pregnancy and gives birth is the only legal mother of the child that she gives birth to. So, in effect, when a surrogate gives birth, even though she may hand over custody of the child to the intending parents, she still remains the legal mother of the child. And as things currently stand, the only way in which you can terminate or transfer parental rights is to get a court order, which is usually an adoption order. So even though you may say, look at it at first blush and it says, "Oh, there are no surrogacy laws in Nigeria," the practice is still affected by existing laws to the extent that a person who engages in surrogacy in Nigeria will not become the legal mother of the child unless they get a court order. Now let's look at what happens to gamete donation. In a gamete donation, a doctor recommends that an intending parent or intending parents should make use of a donor egg or a donor sperm to conceive the child that will be carried either by the intending mother herself or by a surrogate. Again, in Nigeria, we have existing rules about who a parent is, existing laws about who a parent is. And we also have existing laws about how to establish who a mother or who a father is in the event of a dispute. And our laws allow for the courts to issue permission or to grant leave to an intending parent to run a DNA test on the child and on the alleged parent to either establish or disestablish that that person is a parent to the child in concern. Now, in a donor conception where a child is conceived using a donor egg or donor sperm, if a DNA test is run, as is the normal way for establishing parenthood in Nigeria, that DNA test will map to somebody else. The DNA test will not help to solve the question of who the mother is or who the father is if that child was conceived using a donor egg or a donor sperm. So again, even though our laws say that you can use a DNA test in a donor conception, it will not help us answer the question of who the legal mother or who the legal father of the child is. So in these two examples, you find a clear case of where the existing laws in Nigeria are not fit for purpose for the assisted reproduction techniques that we currently are using in the country. Another example of where the existing laws affect assisted reproduction in a way that produces some unexpected results is what in the case of posthumous conception. In a posthumous conception, an egg or a sperm from a dead person is used to conceive a child, and that child is born after the death of the alleged mother or alleged father. Now, our laws allow you to run a DNA test to establish or disestablish maternity or paternity. And our laws, in particular, the Evidence Act, provide that if a child is born to a woman, to a widow, within 10 months of the death of her husband, that child is presumed to be the child of the dead man. So again, our laws provide for only one situation. This child has to be born within 10 months of the death of the alleged father, and that child has to be born to the widow and not to another woman. So in effect, if this child is born outside that 9-10 months window, and if that child is born to another woman, to a surrogate, and not to the widow, that child's paternity is actually in limbo because it falls outside the parameters of the laws that we currently have. And these are some examples of the ways in which the fact that we don't have a comprehensive legal framework affects many aspects of assisted reproductive technologies in Nigeria in ways that people do not expect. I think one of the most common examples is the fact that people tend to assume that because the child has been handed over to them after birth in a surrogacy, that they have actually acquired legal parenthood over the child. But that is not the case. So I think it's very important to understand that even though we say that there are no laws governing surrogacy, for instance, or assisted reproductive technologies in Nigeria, that the existing laws do affect the practices and they bring about results that are not what the people who are engaging in these practices expect. So this just goes to underscore the need to get proper legal advice before you start and to get the advice of a legal practitioner to advise you about how to acquire legal parenthood over a child born in under any of these circumstances if that is the reality that you face. I hope you found value in this video. Take care out there. Bye.